state of Florida in and for the second district is now in session. Judge Stephen T. Northcutt presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Good evening. Welcome to this remote session of the Second District Court of Appeal. If you represent the appellant, Mr. Upson, recall that you are entitled to reserve some of your time for rebuttal. And if you'll let me know when you step up to our virtual podium how much you want to save, I'll give you a heads up when we get there. Our first and only case on this docket is Ricky Tobert versus the state of Florida. So, Mr. Upson, you're up.
May it please the court, Keith Upson for appellant Ricky Tobert. I'd like to reserve 2 minutes, if I may, Judge. Good evening, and thank you all for participating in this special session. The issues briefed are fairly straightforward, and they're all intertwined. We've raised 4 different legal grounds that arise all from the same facts. Legal grounds which support our position that what happened here and how it happened violated Mr. Tolbert's due process, and this court should reverse and remand for a new trial. The first issue necessitates a lot of discussion of the third. The first being that the state made the Williams Rule witness a feature of the trial. Now, during voir dire, the state repeatedly asked the veneer whether they could convict based on one single credible witness at multiple pages, 92, 93, 95, 96, and 100. Why is that remarkable? Why is that significant in this context? Because admittedly, that's a pretty valid way for the state in voir dire to explain and inquire of the panel about the state's burden of proof. And in almost all other cases, no complaint could be made. But right off the bat in the state's closing argument, not rebuttal, which wasn't the first time the state initially discussed the Williams Rule witness in opening, but right off the bat in closing, the state asked, one of the biggest things the state touched on with you in jury selection was one witness. That's at transcript page 682. And then the state said, well, and I may have just something about there being an instruction to that effect before finally wrapping up that thought by saying, but we didn't just give you one, we gave you 3, 2 of which are the crimes charged. So in closing, the first witness the state mentioned by name was the Williams Rule witness. Then the state discussed the testimony of AAW at 683 before explaining how the Williams Rule witness's testimony supported what AAW's testimony had been, and that's at 685. Before asking, what's AAW's motive? What does she get out of this at 9 at page 686? Then the state moved on to discussing TE's testimony before coming back to the ways in which the Williams Rule evidence supported TE's testimony at pages 688 and 89, and adding she, meaning TE, doesn't have the life experience of AE or a grown adult. Quote, the 8 and 9-year-old, we'll get back to that, is not going to describe the same way as the 13-year-old or 26-year-old at 696. So from jury selection to closing, the state was contending that one credible witness was all it took for a conviction. And the import, the significance of that approach wasn't fully apparent until the closing argument. Not the rebuttal, the state's closing.
And
because
Mr. Upson, there is no objection to
That's
this part of
correct.
the closing argument. So this is all fundamental error.
That's That's correct, Judge, which is also intertwined with our. Yes, that's correct.
So if the trial court is not alerted as to this error that you have concluded that pervades this entire case, how can we review this? Fundamental error or what?
It is, Judge. I believe I briefed citing the pertinent authority as to why either making the Williams Rule evidence our first issue a feature of the trial impermissibly constitutes reversible fundamental error, and likewise the third issue of the bolstering, because the effect of that argument, you don't need to believe the two children because you can believe the Williams Rule evidence.
Well, but that's in response to the defense counsel at 710 implying that the Williams Rule witness made it up. So if you take the analysis from Pitts, Fior, Seavey, they all seem to take a quantitative versus qualitative or vice versa analysis. And if you stack this case up to those, we have a 1/2 page reference to her, 15 lines in an opening. And you don't get until her direct of 19 pages and a cross of 13 pages and a redirect of the Williams Rule. And that's in the charged crime offenses, those victims were directed and crossed twice as much. And the state called 7 witnesses for the charged offenses and only AE for the collateral crime. So help me out.
Multiple answers for you, Judge. First of all, I think you referenced something at 710, defense counsel said, and presumably that's going to be the defense's closing argument.
Sure.
I'm still in the 600s.
I understand that.
I'm not talking about the rebuttal argument. And we also, Judge Northcutt, were you
No, go ahead.
Okay.
I was, well, but the judge did instruct the jury on the Williams Rule, give the Williams Rule instruction to the jury.
the instruction was given.
How do we weigh that against, assuming the argument was improper? How do we weigh the two against each other for purposes of whether you've shown the prejudice?
Well, and it's intertwined with the remainder of the response to Judge Fleet's question as well. That CV, and I mean, we have seen some balancing some weight, pages, amounts of time, to clearly define at what point the Williams Rule witness becomes a feature. And I apologize if I didn't brief this well. I thought it was on the page. The state's whole theory of the prosecution here was you don't need to believe the 2 alleged victims upon which he's actually being tried, because you can just believe the Williams Rule witness.
Yeah, I mean, I get that. I mean, the 3 witnesses were the 3 alleged victims they were presented for very different purposes. And the Williams Rule witness was very limited and all of that. And to equate them, I think it was erroneous and harmful. But the judge told the jury, it gave a Williams Rule instruction, which limited how the jury could consider the Williams Rule testimony, correct?
That's correct. It doesn't negate the bolstering or the reliance, the state's entire theme relying on the credibility of that one witness to the exclusion of the other 2.
Right.
That's above and beyond the pale is our position, Judge Sleet, as to what the purpose of the Williams Rule.
Well, the purpose of Williams Rule is no different than 94043B. Collateral crimes, you can prove motive, opportunity, and intent. The prosecutor specifically said motive, which is allowable and permitted by the rules of evidence. That's what he argued. It was the motive. They called this witness last. No other witnesses made any references to the collateral crime incident like the other cases that you find and that you've cited that do reverse on your theory?
Judge, with respect to the state attorney who actually argued in support of the Williams rule, it was a word salad that came out of counsel's mouth. It was literally every word that appears in the statute, and not necessarily in complete sentences. At the Williams rule hearing and arguing for its admissibility, the word motive did come out of the state's mouth, but he didn't explain how this testimony was going to go to any of those factors.
Well, and even given that, you can say, the witness could only prove up motive, lack of mistake, correct? But as a matter of fact, the jury could not have convicted your client if they only believed that one victim. Under the law.
That's correct. That's
Under the
absolutely
law.
correct. Absolutely
Right. So
correct.
to say you only have to believe one of the three is an incorrect statement of what the jury was charged with.
That's correct. And Judge Sleet, I wasn't entirely sure I was going to get into our second issue, but I think it's necessary. The court's express ruling as to why the court was going to allow the testimony. I mean, if you take, for example, the state's supplemental case, Burgess, and I don't have the pagination correct. There is a laundry list on the next to last page with numbers, parentheticals 1 through 6, where the Burgess court, the first district, went through. Here are what we find to be the 6 McLean factors. 1, this, 2, that. Okay, there's a nice enumerated list. At record pages 82 and 83 here, the court says almost as many things as to exclusion as the court did inclusion. The majority of the abuse from all 3 victims occurred in the barbershop. Okay, that's one thing in common, all in the barbershop.
Well, that's a pretty big factor, don't you think?
I don't, Judge.
They were all minor girls allegedly molested in a private room in a barbershop.
Barbershop
You
where,
don't find that distinctly unique?
Judge, it's 1 of 6 and it's where he
The
worked.
barbershop where he works.
Not enough alone, Judge.
I'm not saying
Well,
that's what the judge relied upon.
Mr. Upson, on a sort of macro level, the similarity issues, I think in the McLean opinion and echoed in the first DCA's case in Easterly, similarity is sort of minimally required as long, and we look at it in terms of relevance. And here, that's obviously a balancing test, and you're asking us to conclude that the trial court abused its discretion on the basis of these 3 things that happened in the same place with the same guy and that do have at least some similar characteristics. I'm struggling with that.
Well, I did hope when I briefed what I'm about to say in response, it didn't sound flippant in the reply brief, that aside from the barbershop, what these 3 incidents have in common is a touching and on someone under a certain age. And by definition, all LNLs under 16.
But Mr. Upson, as Judge LeBrit pointed out, these were 3 victims, all with the same guy. There was no question of identity here.
There was no question of identity.
In which case, this is a sort of a balancing test in terms of the level of relevance. If there was an identity issue, you would logically look for a closer thumbprint.
Well, and while we're talking about discretion, to the extent I'm not running out of time, I really want to go back to the actual express findings of the trial court in deciding to admit it.
You got 5 minutes before you get to your rebuttal time. So,
One of which was that the prior act, the Williams rule, and again, I believe this is page 82 of the record, 82, 83. The prior act occurred in 2010. The incidents in this case occurred in 2018.
Wait,
So,
on the temporal stuff, I really have issues with that. In McLean, it's clear from that opinion that the Williams rule witness testified about acts that occurred 15 years earlier, and the Supreme Court didn't have a problem with that. And in I think it's the CV case, yes, where the similar crimes were 16 and 25 years earlier. So, and again, not a problem. I'm not sure that the 10-year passage of time here has much to do with anything in terms of whether the trial judge abused his discretion in finding relevance here.
Judge, I'm gonna try really hard to get to the part of 82 and 83 that I want to get to.
I've got it right here, so I'm all ears.
However, the prior act does tend to negate any implication that the victims in this case had a motive to lie or make up the abuse. It's not the victim's motive that permits introduction of prior bad acts under the Williams.
But the whole reason the legislature authorized this relaxed standard in this context is for corroboration purposes because of the unique nature of sex bat crimes on children. And that's what the state used it for.
And also, Judge, why in CV and in McLean, those courts were able to articulate more factors that were in common than were disparate. Here alone, the passage of time was not enough. But I began trying to read the part of this court's express findings by saying, in Burgess, we've got 6 parenthetically annotated, this was similar, right? What do we have here? We have, well, it was really far apart in time. The type of the conduct was dissimilar. There was touching underneath the clothing that the court allowed her to testify to at trial. That's dissimilar. She was older. She was more developed. That's dissimilar. I'm not seeing the 6 or anywhere close to it that would have gotten this court there. And because of the nature of the prior act testimony, once you ring that bell, and here's my exhibit on why it mattered. It's how the state drove a freight train through that hole once it was open. You don't have to believe the 2 alleged victims of this crime because we brought you an articulate, grown woman. Just believe her and convict them of these 2 crimes. Respecting that the trial judge has a tremendous amount of discretion and that there were some purposes for which a limited amount of this testimony would have been permitted under the statute. This is what it looks like when the court just lets it all in without regard for any of the enumerated factors. And again, Judge Sleet, I appreciate, and you may all have very strong feelings about the fact that it was a barbershop. Okay, it was a barbershop and it involved touching
It's a barbershop with the guy that covers people's eyes and puts them in his lap. And, I don't have to get too graphic about the rest of it, but it had other common elements.
Well, just one, if I recall.
It could be a law office. I mean, this could be a lawyer in a law office. It's just there's similar surroundings, similar circumstances, similar age children, with him having them touch him or him touch them. Inappropriately, allegedly.
Well, which judge are going to be factor or elements of every single L&L charged in the state. So we either have some evidentiary threshold to allow this in or exclude it, or we rewrite the statute and we just say, you know what, we don't care. If you touch somebody under a certain age, it's all coming in. That's it. That's the standard.
You're right at your 2-minute rebuttal time, Mr. Upson, so you use them as you please.
I shall not. Thank you, Judge.
Okay, thanks. Okay, Mr. Goff, it's your turn.
Wayne Goff on behalf of the state of Florida on the appellee in this case. First, I'll address issue number 1, which alleges that this became a feature of the trial. As Mr. Upson noted, it was unpreserved by a contemporaneous objection that it became a feature of the trial, and also there was no motion for mistrial, then it became a feature of the trial. Therefore, it's unpreserved and it should be.
But you would acknowledge, Mr. Goff, that the statement, you only have to believe one of the three, was not legally correct.
Austin.
We've lost him. Okay. Well, I'm going to stop the clock.
There he is.
There you are.
That's correct. I was able to hear you. I'm sorry, but that.
All right, that's okay. We just thought we lost you. And now I stopped the clock and I'm starting it back. So
Yeah, that's correct. Saying that is legally incorrect, that you only have to believe one witness. But however, this evidence did not become a feature of the trial, which is defined as when it's presented no longer for the development of facts pertinent to the main issue of guilt or innocence.
Mr. Goff,
yes.
your opponent makes a somewhat compelling argument that starting with voir dire and tracing the components of the voir dire through the state's handling of the Williams rule evidence during the trial and up to and including the closing argument. Can you address that? It wasn't something that we lost him again.
stopping the clock again. There he is.
I can hear you when that's going out. I'm sorry. I apologize. I'm not sure what's going on with the camera here.
I think it's
That's all right. And I think, obviously, if we see your like Brian Goff up there, we still have you online. But so, all right, go ahead.
Anyway, my question was to ask you to address your opponent's sort of thematic argument that this became a feature of the trial, starting with voir dire. And he's highlighted, obviously, the precise parts of the record. And it does, he's got something to talk about on that thematic argument. So I'd like to hear from you.
I believe you previously acknowledged that.
We can't hear you, Mr. Goff, or I can anyway. Great.
Okay, the special instruction was given prior to any testimony given and prior to the witness actually testifying and prior to their deliberations, that they were to consider this evidence for the sole purpose.
And the jury was told this before this young woman testified, or at the time she testified, and told in the closing instructions.
Correct. And every time the prosecutor, or most times the prosecutor mentioned it in opening and closing, they referenced, now you got a special instruction, you're gonna get a special instruction, and you're to consider it for that purpose. So that they were well informed that that was the purpose for the testimony. In terms of the amount of pages of transcript, as I cited in my brief, that is not necessarily a determinative factor in whether or not it becomes a feature of the trial.
Colin?
Well, we've lost your audio, Mr. Goff. There
And if it's okay, I'm trying to power through this, but the Burgess case that I cited, and also McLean, there's multiple witnesses, 6 witnesses in Burgess. I think there's multiple witnesses in McLean, all testifying to try to corroborate just the Williams rule. In this case, it was just one witness testifying to it. So that's also a factor to be considered on whether or not this became a feature of the trial. But the pure amount, I think there was some citations to how much a percentage of the trial transcript took up mentioning the Williams rule witness really isn't a determinant factor on whether it became a feature of the trial. And as mentioned previously by Judge LaBrette, that the law is tolerant on child sex victim in these cases when they're the sole witness to the event and identity is not an issue and there are no people around. The law is more tolerant of this, and that's because it's an unlevel playing field when you're being cross-examined by an adult attorney and that the defendant is an adult. That's why the law is tolerant. This is a 7-year-old and a 10-year-old
Okay, we lost your audio again, Mr. Goff.
And they're not able to adequately describe exactly what happened to them. Would you like me to power through, or do you want me to try to get help? I can keep doing this. It looks like
it's your call. I mean,
I'll try to power through, but if this gets too much, you just let me know, and I can.
Last week I was in oral argument, and my internet kept going out of my house. So I get it.
Okay. And so anyway, the child, because a 7-year-old and a 10-year-old can't adequately articulate what exactly appellant was doing to them because of their life experiences, that's why this Williams rule evidence is used to corroborate this type of behavior, that it wasn't an absence of mistake, a modus operandi, and corroborate. That's exactly what the statute was intended for the Williams rule. So there's no issue.
Did he say if there are no further questions, he was going to stop? I don't know. We'll let him come back.
No, I didn't say I was going to stop. I'm going to address admissibility. This is an abuse of discretion standard, so it's got to be that no other reasonable judge in this situation would rule this way. And you can't say that in this case. The trial court went through the proper factors. First, was it proved by clear and convincing evidence? And the trial court reviewed the evidence of the Williams rule witness and said that yes, she was unhesitant and very specific about the facts. She was an older witness and testified as to what happened to her. So that factor exercised its discretion and determined that it was proven by clear and convincing evidence. The second factor was relevancy. It was proven that this was for corroboration under the statute, what the statute's intended purpose was in a child sex crime. And also for modus operandi, this is a common theme that he uses, and for
You went back out. Here he comes. Oh. Yeah.
okay, so
There's kind of a pattern when your audio starts to glitch, and then your video goes, and then you probably have like a buffering issue or something. Go ahead. It's not like I'm talking about.
I apologize. I really do.
Not your fault.
I'm sorry. It was proven to disprove lack of mistake for modus operandi and corroboration in child sex victim. So it was relevant. And so then the next factor under McLean is whether or not the 403 balancing test has a prejudicial effect outweigh the probative value. And the trial court went through the factors. Similarity. These were sufficiently similar in the actions alone, which was pointed out previously by Judge Sleet and Judge LaFreda, I believe. And if you need me to review how the behavior was, not to get into too much detail, but also Burgess, which I cited, means of access could be considered, and in this case, means of access using coworkers at the barber shop, bringing their kids to work while their back is turned, while they're on the phone or distracted, and touching these children during that time is sufficiently similar under Burgess. Means of access is similar. Also, the conduct is similar. So this was sufficiently similar under McLean, and the trial court was able to exercise its discretion, reviewing all of those factors, and determine that this was admissible under McLean. And dissimilarities, specific dissimilarities, are not fatal to admissibility in these cases. It doesn't have to be exact.
Yeah, you disappeared again. There you go.
So, and also, even if this court did find it was error, it's harmless error. These acts could have been proven with the witnesses that the state presented. The CPT video, the person conducting the CPT interview was also corroborated their testimony. The parents testified in the investigating officer. So all the elements of the charged crime were met even without this witness. So even if this court were to consider that it was error, it would do harm. Any error should be considered harmless. Moving on to issue 3, the improper bolstering. There was no objection made during closing arguments or opening statements as to improper bolstering, so it's to be reviewed under fundamental error analysis. And that cannot be said that this was fundamental error in this case. It was proper comment for the prosecutor using the special instruction to comment on evidence that was presented. And as Judge Sleep pointed out, in the defense's closing arguments, they did challenge the credibility. This was just a mistake. This was a misunderstanding. The 7 and 10-year-old doesn't really can't tell you exactly what happened to them. And I think there was some implication that he was leaving the barber shop and therefore this.
There he goes.
Okay. I'm sure that Mr. Goff can tell he's not sure. There you go.
So, and I can tell when my video goes on. I'm sorry about that. So therefore, during closing arguments, they were able to fairly comment and rebut what that this was a lack of mistake or their credibility questioning. So they were allowed to go back and use it for what its intended purpose is corroboration. And finally, cumulative error doesn't exist because none of this was error. So if this court has no further questions, I would ask that you affirm this case, and I apologize again for the technical.
It's not your fault. You did well under the circumstances, Mr. Goff. So thank you. All right, Mr. Upson, 2 minutes.
You can't preemptively rebut. You notice I haven't said a word about the state's rebuttal argument. I'm highlighting the error that occurred in the state's closing, and candidly, the bolstering alone is enough. And I don't think, though, of course, whatever's on the page could prove me wrong, I don't think any of the impermissible bolstering cases I ever rely on were preserved. I think it's all.
Any personal vouching for the truthfulness or veracity of her by this prosecutor?
Judge, in context, every one of the statements that I referred to that pointed to, well, of course, we've got the classical, what's AAW's motive? What does she get out of this at age 9?
And AAW is a charged victim.
That's correct.
Okay, so you can balance out the motives and compare them and contrast them.
Well, respectfully disagree, Judge. That's not ever fair.
You can't. You can't question the motive of a victim of a crime. It's done all.
What does she get out of this is an analog to the quote about the officer in the briefs that I quoted, in the case that I quoted. Does her pay go up as a result of her testimony? What does she get out of this? It's textbook bolstering. Had that statement been made in rebuttal to rebut the defense of fabrication, different story. You don't get to.
Does that come in line with the instruction that the jury gets every case? Was there any bias or inconsistency on the part of the witness? Were they candid? Were they truthful?
Judge, I would offer
an interest in the case.
It's a fundamentally different statement for the state to satisfy its obligation to that instruction in closing and say, you heard the witnesses, you can consider this, you can consider that. At the point the state of Florida begins to say, this person doesn't have a motive to lie, therefore they're telling you the truth. It's textbook bolstering.
Your time is up, Mr. Upson.
Thank you.
Thank you both very much. And typically at this point, I would say click the leave button, but I don't know if you're supposed to if you're going to hang